Module 2. Children and the GDPR. Introduction. Children need particular protection when you are collecting and processing their personal data because they may be less aware of the risks involved. If you process children's personal data, then you should think about the need to protect them from the outset and design your systems and processes with this in mind. You need to have a lawful basis for processing children's personal data. Consent is one lawful basis for processing, but it is not the only option. Sometimes using an alternative basis is more appropriate and provides better protection for the child. If you are relying on consent as your lawful basis for processing personal data, when offering an online service directly to a child, only children aged 13 or over can give consent. Think Facebook. Children merit specific protection when you use their personal data for marketing purposes or creating personality or user profiles. You should not usually make decisions based solely on automated processing about children if this will have a legal or significant effect on them. You should write a clear privacy notice for children so that they are able to understand what will happen to their personal data and what rights they have. Children have the same rights as adults over their personal data. These include the rights to access their personal data, request to look at their personal data, object to processing, and have their personal data erased. An individual's right to erasure is particularly relevant, and if they give their consent to processing when they were a child. This presentation focuses on additional child-specific considerations. This must be read in conjunction with the guide to GDPR so that you are meeting your requirements both to adults and children. You need to consider the level of protections you are giving that data. Transparency, accountability are important where children's data is concerned. The GDPR contains provisions intended to enhance the protection of children's personal data and to ensure that children are addressed in plain, clear language so that they can understand their rights. A child is defined as someone under the age of 18 years. This is in accordance with the UN Convention on the Rights of the Child, which defines a child as everyone under 18 unless under the law applicable to the child majority is attained earlier. So what is new? A child's personal data merits particular protection under GDPR. If you rely on consent as your lawful basis for processing personal data when offering an online service directly to children, only children 13 or over can give consent. For children under 13, you will need to get consent from their parents or carers unless the service you offer is online, preventative or a counselling service. Reasonable steps must be taken to verify that the person providing consent is in fact the one that holds parental responsibility. You should not make decisions about a child based on automated processing. The circumstances in which GDPR allows you to make such decisions are limited. You must also have a clear age-appropriate privacy notice for children. The right to have personal data erased is particularly relevant when the individual gave their consent when they were a child. What should our general approach to processing children's personal data be? As with adults, you need to have a lawful basis for processing a child's personal data, and you need to decide what that basis is before you start processing. You can use any of the lawful basis for processing set out in the GDPR when processing children's personal data, but for some bases there are additional things that you need to think about when your data subject is a child. If you wish to rely upon consent as your lawful basis for processing, then you need to ensure that the child can understand what they are consenting to. Otherwise, the consent is not informed and therefore invalid. There are also some additional rules for online consent. If you wish to rely upon performance of a contract as your lawful basis for processing, then you must consider the child's competence to agree to the contract and to understand the implications of this processing. If you wish to rely upon legitimate interest as your lawful basis for processing, you must balance your own or a third party's legitimate interest in processing the personal data against the interests and fundamental rights and freedoms of the child. This involves a judgment as to the nature and purpose of the processing and the potential risk it poses to children. It also requires you to take appropriate measures to safeguard against those risks. How does the right to be informed apply to children? You must provide children with the same information about what you do with their personal data as you give to adults. It is good practice to also explain the risks inherent in the processing and the safeguards you have put in place. You should write in a concise, clear and plain style for any information that you are directing to children. It should be age appropriate and presented in a way that appeals to a young audience. If you are relying upon parental consent as your lawful basis for processing, it is good practice to provide separate privacy notices aimed at both the child and the responsible adult. If you provide an online service, ISS, and the children are younger and that's your target range, then you are likely to try and access it, and it is good practice to explain that any age limit to them in a language that they can understand. Children have the same rights as adults over their personal data, and they can exercise their own rights as long as they are competent to do so. When a child is not considered to be competent, an adult with parental responsibility may exercise the child's data protection rights on their behalf. How does the right to erasure apply to children? Children have the same right to have their personal data erased as adults. This right is particularly relevant when an individual originally gave their consent to processing when they were a child, without being fully aware of the risks. One of the specified circumstances in which the right to erasure applies is when you collected the personal data of a child under the lawful basis of consent, especially when offering an online directly to children. It should generally be as easy for a child to exercise their right to erasure as it was for them to provide their personal data in the first place. How important are fairness and the data protection principle? Fairness, compliance and data protection should lie at the heart of all processing for children's personal data. To protect the interests of the children. Protecting the interests of the children is central to everything you do with the child's personal data. To be transparent, talking to children, being open with children and letting them know what to do if they are unhappy. What do I need to do about data protection by design and default? Firstly, to provide specific protection from the outset when designing systems and policies and procedures for children in our settings. To use the data protection impact assessment form to help develop systems which mitigate data protection risk to children. To take into account age-appropriate rights and freedoms of the child, so their freedom to learn, explore and develop, particularly online, is only restricted when this is proportionate. And lastly, to be transparent, talking to children, being open with children and letting them know what to do if they are unhappy. Should we consult with the children? Yes, this is excellent practice and will allow you to design processes such as policies and procedures, privacy notices, which are in line with the requirements of the children. The feedback that you gain from the children will be invaluable, as it will allow you to understand them better and gather information based on the different range of diverse groups. It will also help you as a setting to identify risks, design safeguards and assess understanding, allowing you to provide the opportunity to test your systems on the end user, the child. It is also consistent with the UN Convention on the Rights of the Child, which provides at Article 12 that every child has the right to express their views, feelings and wishes on matters affecting them, and to have their wishes considered and taken seriously. What do we need to think about when choosing a basis for processing children's personal data? What is the basis for storing and processing children's personal data? What is your lawful basis for doing so? Well, in order for us to comply with the EYFS framework, you as a practitioner must ensure that you've collected the relevant data on a child so that you can fully understand and meet the needs of that child. The kind of data that you'll be collecting are things like personal data such as date of birth, allergy information, likes, dislikes, development milestones. Such information forms the basis of the care and education that you will offer the child. Without this data, the level of care you would be providing would not meet the requirements of the child. Therefore, it is essential that this data is collected, hence giving you lawful basis. You must make parents and carers, and where appropriate, children, aware of how you intend to share this data and who with. The necessary consents must also be obtained. You will need to ensure that the parents and carers, and where appropriate, the child fully understands what they are consenting to and why. Otherwise, the consent is not informed and therefore invalid. Think about how you will do this. If you wish to rely upon legitimate interest upon a lawful basis for processing, you must balance your own or third-party legitimate interest in processing the personal data against the interests and fundamental rights and freedoms of the child. This involves a judgment as to the nature and purpose of the processing and the potential risk it poses to children. It also requires you to take steps to minimise that risk. What if we are relying on consent? The GDPR allows you to process personal data on lawful basis of consent. The data subject has given consent to the processing of his or her personal data for one or more specific purposes. There may be circumstances in which you wish to process a child's personal data using consent as the lawful basis for processing. In this instance, you should bear in mind that consent puts the onus on the child or their parent to decide whether the processing is acceptable or not. Although consent is a lawful basis for processing alternative children's data, using it does not necessarily guarantee that the processing is fair. Consider the competence of the child and whether they are able to understand the implications of the collection and processing the data. If they do have understanding, then they are considered competent to give their consent, unless it is evident they are acting against their own best interests. Take into account any imbalance in power in the relationship to the child. Ensure consent is freely given. In England, Wales and Northern Ireland, there is no set age to which a child is considered to be competent to provide their own consent to processing. In Scotland, children aged 12 or over are presumed to be of sufficient age and maturity to provide their own consent for data purposes, unless the contrary is shown. If you accept consent from a holder of parental responsibility over a child, then you need to think about how you will get that consent reaffirmed by the child when they become competent to provide their own consent. The ICO recommended that you are clear that this needs to happen at the time when you collect consent from the holder of parental responsibility, and that you personally engage with the child about this too. As the child approaches the age of digital consent or develops their understanding and competence, both parent and child are already aware that the child will need to provide their own consent for the processing to continue. Performance of contract. What is it? The processing is necessary for the performance of a contract to which the data subject is party or in order to take steps at the request of the data subject prior to entering a contract. If you enter into a contract with a child, you must consider their competence to agree to the contract and understand the implications of the associated processing of that personal data. This would apply to settings where they care for children over the age of 12 or involve children in the sign-up contract process with their parents. In Scotland, no child under 16 can enter into signing a contract. There are exceptions. In the rest of the UK, there is no definitive age basis, but the basic rule is children over the age of 7 are generally able to enter into contracts, but in some cases the contracts could be voidable. This means that you cannot hold the child to what they have agreed to or enforce the terms of the contract against them. If a contract is voided, then you do not have the lawful basis for processing the data. This applies in all circumstances, including where you're offering an online service. If you are considering entering into a contract or processing data with a child, the ICO recommends that you seek your own legal advice about the validity of the contract, as this may affect whether or not you have a lawful basis for processing their data. Similarly, if you are thinking about allowing a parent to agree to a contract with you on behalf of a child under a power of attorney, you should again take legal advice. But what does this really mean? What does it mean in terms of childcare? Well, explaining in age-appropriate terms to the child and family why you are collecting data. Explain how that data is stored. Look at how and why the data is shared. Photographing children using their images for observations. Photographing children and using their images on display boards. Photographing children and using their image in marketing material both online or on paper. Think about how you will share the data via electronic means and how you will encrypt any images or sensitive information. It's really important that you think clearly about the contracts you currently use and how they will incorporate the new information with regards to GDPR, and how you will clearly show how you've obtained the correct consents in order to process data. Let's now look at special categories of personal data. What is a special category? Special category data is personal data which the GDPR says is more sensitive and so needs more protection. In the case of childcare, this could mean health information, medical details or developmental issues. In order to lawfully process special category data, you must identify both a lawful basis under Article 6 and a separate condition for processing special category data under Article 9. The two do not have to be linked. There are 10 conditions for processing special category data in the GDPR, but the Data Protection Bill will introduce additional conditions and safeguards. You must determine your conditions for processing special category data before you begin this processing under GDPR, and you should document it. So what's different about special category data? You must still have a lawful basis for processing under Article 6 in exactly the same way as for any other personal data. The difference is that you will need to satisfy a special condition under Article 9. This is because special category data is more sensitive, so therefore needs more protection. For example, information about an individual's race, ethnic origin, politics, religion, genetics, health, sexual orientation. It is really a good point now to look at the definition sections of this guide for further details, and I've given you the link below. In particular, this type of data could create more significant risk to a person's fundamental rights and freedoms, for example, by putting them at risk of unlawful discrimination. Your choice of lawful basis under Article 6 does not indicate which special category condition you must apply, and vice versa. For example, if you use consent as your lawful basis, you are not restricted to using an explicit consent for special category processing under Article 9. You should choose whichever special category condition is the most appropriate in the circumstances, although in many cases there may well be an obvious link between the two. For example, if your lawful basis is vital interest, it is highly likely that Article 9 condition for vital interest will also be appropriate. Although online services may not be directly associated with childcare, we felt that it's just good to put this in so that you're aware. So what are the rules about ISS, online services and consent? Here we're thinking about Facebook, Instagram, that kind of thing. There are many consents regarding the child and online businesses. As you are a childcare provider and not offering an online service directly to children, this does not involve you signing children up electronically. So we're not going to delve too much into this piece of legislation. However, we just want to make you aware. An ISS online service could be like signing up to Facebook, Instagram, Twitter. The UK has set this age limit for consent to join such online platforms at 13 years of age. What if we want to market to children? Children merit specific protection when you are using their personal data for marketing purposes. You should not exploit any lack of understanding or vulnerability. They have the same right as adults to object to you processing their personal data for direct marketing. So you must stop doing this if a child asks you to do so. If you wish to send electronic marketing messages to children, when you also need to comply with the Privacy and Electronic Communication Regulations 2003. Let's look at what we already do in our settings and ask ourselves some questions. So, do we comply with all the requirements of GDPR? Not just those specifically relating to children and that are included in the checklist. Do we design our processing, i.e. policies and procedures, privacy notices, in mind from the outset, and do we use the data protection by design and default approach? Do we make sure that our processing is fair? And do we make sure it complies with the data protection principles? As a matter of good practice, do we use DPIAs to help and assess and mitigate the risk to children? If our processing is likely to result in high risk to the rights and freedom of children, then we always should do a DPIA. As a matter of good practice, we should consult with children as appropriate when designing our processing. So, do we, when relying on consent, make sure that the child understands what they are consenting to? And do we not exploit any imbalance in power in the relationship between us? Let's think about that for a second. When relying on necessary for the performance of contract, do we consider the child's competence to understand what they are agreeing to when entering into that contract? Now, some of you probably do not do contracts with children because you do the contracts with parents when you're taking them on for childcare. But some childcare professionals, especially in childminding, do actually talk to the children and see what they want in their contract, the kind of food that they like, things like that. When relying upon legitimate interests, do we take responsibility for identifying the risk and consequences of processing and put age-appropriate safeguards in place? So we're looking at solely automated decision making, including profiling. What is profiling? Profiling means any form of automated processing of personal data consisting of the use of personal data to evaluate certain aspects relating to a natural person, in particular to analyse aspects concerning their natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behaviour, location or movements. The rule in Article 22 of the GDPR relates to solely automated decisions rather than the process of profiling in itself. This means that profiling that is not used to make decisions about a particular individual or profiling that feeds into a wider decision-making process with a human element isn't covered by Article 22. If Article 22 does not apply, then as long as you make sure that you give specific protection to the child in accordance with Recital 38, the GDPR does not prevent you from profiling children. But you should still need to meet the other requirement of GDPR, such as processing fairly, having a lawful basis for processing, and providing a privacy notice which the child can understand. You should be clear about what you are doing and why, and not exploit the lack of understanding or vulnerability of the child. If you do not make automated decisions about children, then this doesn't apply. But you must still make children and parents aware of how you use their data when it comes to profiling and processing information about them in order to ascertain information relating to their learning, development, health and well-being. Privacy notices. You must have these. Ensure that the privacy notices are clear, written in plain, age-appropriate language. Use child-friendly ways of presenting privacy information, such as diagrams, cartoons, graphics, videos, dashboards, layers, symbols, icons. As a matter of good practice, explain the risks inherent in the processing and how you intend to safeguard against those risks in a child-friendly way, so that children and their parents understand the implications of sharing personal data. Tell children what rights they have over their personal data in the language they understand. As a matter of good practice, offer 2 different versions of privacy notices, one aimed at the holder of parental responsibility and one aimed at the child. Processing needs to be fair and transparent. Your privacy notice will need to be clear and accessible and aim to educate the child about the need to protect their personal data. How should you provide privacy information? You should write in a clear, concise, plain style for any information you are directing to children in a privacy notice. It should be child appropriate and, as far as possible, addressed directly to the relevant age group. If you are relying on parental consent as your lawful basis for processing, then it is good practice to provide both a child-friendly and adult version of the privacy notice. This will give the consenting parent the information that they need and help inform and educate young children for the future, enable them to exercise their rights on their own behalf should they wish. You should present your privacy policy notice in a way that is appealing to them, as we have just said in the slide before, using diagrams, cartoons, graphics or videos that will attract their interest. Children's data protection rights, empowering our children. Children have the same rights as adults over their personal data. They can exercise their own rights as long as they are competent to do so. Where a child is not considered to be competent, an adult with parental responsibility may exercise the child's data protection rights on their behalf. So what do we currently do in early years? What can we do in early years in order to ensure that children's data protection rights are protected? Perhaps we're already doing this. However, let's just have a closer look. In our settings, what we can do is design processes such as policies and procedures by which a child can exercise their data protection rights. These must be designed with children in mind and make them easy for children to access and understand. We must allow competent children to exercise their own data protection rights. If our original processing was based on consent provided when the individual was a child, then we must comply with the requests for erasure whenever we can, i.e. we have to get rid of their documents on their request because they have the right to be forgotten. We must design processes that, as far as possible, it is as easy for a child to get their personal data erased as it was for them to provide us with the information in the first place. Rights and exercising those rights. All data subjects, which include children, have a right to be provided with a transparent and clear privacy policy which explains who you are and how their data will be processed. They also have a right to be given a copy of their personal data, as well as have the right to have inaccurate personal data and incomplete data rectified and completed. Children can also exercise the right to be forgotten and have personal data erased. Data portability. For example, where do you port that data? Who do you give it to? Perhaps it's a child leaving your setting to go to school, so therefore you'll be porting that data directly to the school in which they're going to. Explain this to the child and the parent and why. They have a right to object to processing carried out under lawful basis of public task or legitimate interest and for the purpose of direct marketing. They have the right not to be subjected to automated individual profiling, which produces legal effects concerning him or her. They also have the right to complain directly to the ICO or another supervisory authority. And then they have the right to appeal against a decision of that supervisory body. They also have the right to bring legal action against a controller or a processor, you basically, and they can claim compensation from that controller or processor for any damage suffered as a result of the non-compliance with the GDPR. A child may access their rights as above as long as they can show competency. In Scotland, as we've discussed before, a child aged 12 or over is presumed competent unless shown and proven to the contrary. This presumption does not apply in England, Wales and Northern Ireland, where competence is assessed due to level of understanding. A child should not be considered competent if he or she is acting against their own interest, but the child can authorise someone to act on their behalf. This is usually the person with parental responsibility. Even if a child is too young to understand the implications of their rights, they are still the right of the child, rather than anyone else.
such as a parent or guardian. You should therefore allow parents to exercise these rights on behalf of a child if the child authorises them to do so, when the child does not have sufficient understanding to exercise such rights. This applies in all circumstances, including in an online context.
So what does this mean in practice? An adult with parental responsibility may ask you for the copy of their child's personal data, or they may attempt to exercise one of the child's other rights on their behalf. If you, the controller / processor, are satisfied that the child is not competent and the person who has approached you holds parental responsibility for that child, then you may only at this point respond directly to the adult. If you are confident that the child can understand their rights, then you should usually respond directly to the child. You may, however, allow the parent to access the child's right on their behalf if the child authorises this, or it is evident that this is in the best interest of the child. Let's look at the borderline and what you must consider. Firstly, consider the child's level of maturity and their ability to make decisions. Secondly, the nature of the personal data. Thirdly, any court orders relating to the parental access or responsibility that you may apply. Any duty of confidence owed to the child or young person. Fifthly, any consequences of allowing those with parental responsibility access. This is particularly important if there have been allegations of abuse or ill treatment. Any detriment to the child or young person if individuals with parental responsibility cannot access this information. And lastly, any views the child or young person has on whether the parent should have access to the information about them. Okay, so what does this look like in practice? So if an individual wants you to erase their personal data that they have provided to you when they were a child, then you should comply with their wishes wherever you can. However, the right to erasure is not an absolute right, and it can be overridden in certain circumstances, including where it is necessary for exercising the right of freedom of expression and information. When considering whether the right to erasure should be overridden in this case, you should take into account that freedom of expression is itself a qualified right. It may be restricted if this is necessary for the protection of rights of the others. So effectively, you need to balance the right to freedom of expression against the need to protect the rights of others. In a situation where a data subject provided their data when they were a child without fully realising and understanding the implications of doing so, there will generally be an increased expectation of what may be considered necessary to protect the rights of the child. So the right to erasure is more likely to prevail in this circumstance than if data was provided by an adult. This will have to be decided upon by you on a case-by-case basis. You need to make sure that the process for exercising the right of erasure is easy for a child to assess and understand. Article 7.3 of the GDPR says it shall be as easy to withdraw consent as it was to give it. In an online context, dashboards, takedown tools should be available to allow children and other users to easily delete or remove their data. Facebook, Snapchat and other online social media platforms already do this. I'm telling you this simply because you can assist parents in helping them to understand the rights of in which their children have. If a child basically is able to give their own consent to processing and to exercise their own data protection right, you should accept a request to erase personal data from a holder of parental responsibility without taking the wishes of the child into account. And there could be a number of reasons for that. Maybe the child isn't competent or deemed not competent. So again, it's a case-by-case basis. In cases where there is a dispute between a child and parent about whether personal data should be erased or not, or where a child wishes to have their data erased without parental knowledge, then you have to consider the level of understanding of the child. So again, competency and what's in the best interest of the child. This again is done on a case-by-case basis. Let's have a look at the data protection officer. Although there isn't a legal requirement under EYFS or under the rules of the regulations of GDPR for the childcare setting, in particular childminders, to appoint a data protection officer, it will be considered excellent practice and will demonstrate how your setting implements GDPR. And also it's just someone that you can turn to and talk through what you need to do. They can make sure that you're compliant, basically. That's the whole idea. They're there to support. A data protection officer will be tasked with some specific duties. These could be to ensure that the childcare setting is compliant with GDPR, to conduct an audit of the setting to establish what data is currently kept, how it is stored, to establish an information asset register and to maintain that register. In the event of a breach of GDPR or data, the DPO will conduct an investigation and report to the appropriate personnel, to establish policies and procedures and to make sure that these are delivered to staff so that all staff understand their responsibilities under the new law, and this includes ensuring that staff are appropriately trained in GDPR.